Okay, I thought we would have the PowerPoint file somewhere here, but probably not. Okay, whatever. Well, I'm going to talk about the admission of judges who worked in an undemocratic regime, in this case East Germany, to the bar in the West German legal system. European attorneys will usually face a lot of hurdles when they want to work in another country. EU law now allows you to practice in other legal systems, as does WTO law to a certain extent, but we still face a number of hurdles because you're trained in one specific legal system, which makes it more difficult for lawyers than for doctors to transplant their knowledge and their skills to another legal system. But what happens if it's not you who want to move to another country, but what if the legal system suddenly changes around you when you're still in your hometown? And that's exactly what happened to a lot of lawyers in East Germany in 1990. They were trained in one particular legal system, the East German legal system, and almost overnight they found themselves living in a different country. And so far as the entire legal system of Western Germany was imposed on East Germany. There were some rules which still applied, some Eastern rules which still applied in the eastern parts of Germany after the reunification, but only for a limited time. Essentially, on reunification day on 3rd of October 1990, the East German legal system ceased to exist. Now, the problem is then, you have lawyers who've been working there. You have judges, you have attorneys. What do you do with them? What can they do? On one hand, they have legal knowledge, they have skills. On the other hand, you suddenly have a legal system which needs lawyers, which is in desperate need of lawyers because of a large number of changes in the domestic law. The question then is, can you use the expertise which is already in place? On one hand, we're talking about legal skills. Skills is something which you can apply in different legal systems. On the other hand, we're talking about knowledge. Knowledge overnight practically became useless for a lot of these lawyers. When it comes to skills, these skills were not only useful, but they were actually needed, because you needed people who are skilled in implementing laws. Now, when we're talking about attorneys who worked in East Germany, it probably was fairly easy, in particular in the field of private law. The Western laws which applied overnight in East Germany, they're well known, there had been a lot of textbooks, so it was fairly easy for attorneys there to study up on the West German law, to learn the West German law of contracts, and so on. There were a lot of courses, but within a fairly reasonable time it was possible for East German attorneys to work in the new legal system. But what do you then do with judges? People who've been working in East Germany, who've been working for the regime there. That's of course a completely different approach to law, and it's also a different set of skills, a different knowledge you have. Thanks. For attorneys, as I said, there's legal training, but what do you do with judges? What do you do with prosecutors? Can they actually be quickly trained, or this past experience, what does it actually mean for the practice of law in a new legal system? And the question which then arose was very quickly, can we even admit those people to the bar as attorneys? Can we allow people who work for the for the socialist regime as judges, as prosecutors, in politically motivated cases? Can we allow those lawyers to use their skills, not as judges? There were only a handful of judges from East Germany who were allowed to work as judges after reunification. But can we at least allow them to work as attorneys in the new legal system? Which brings me to the role of the attorney in the legal system in Germany. The attorney is not just a commercial actor, but serves the legal system as a whole. We are, as attorneys, required to maintain a certain standard of quality, but also a certain standard of integrity, as we've heard earlier already. The question is then, does the standard of integrity which is expected from attorneys, can it still be achieved if there have been prior involvements in this case, an undemocratic regime? Which in turn brings us to the requirements to be admitted to the bar in Germany. On the one hand, there are academic requirements. This is something you can test easily. You can put in place special exams, for example, for East German lawyers, for East German judges, if they have the sufficient knowledge to practice law in the United legal system. But the bigger problem is the second point here. There must be no serious prior convictions. A serious prior conviction is one which carries a sentence of imprisonment for 1 year or more. And this brings with it the question, is this person suitable for the legal profession, for the profession of attorney? In a number of cases, the question had to be asked whether the prior service for the socialist regime as a judge or an attorney provided an automatic impediment to the admission to the bar in reunified Germany. There's no general answer to this. In many cases, you will have a judge who probably just did, let's say, contract law, which in East Germany was very similar to West Germany. That would not necessarily have been an impediment to practice as an attorney in reunified Germany. But in cases of perversion of justice, which you would have in many criminal law cases, the answer would be usually yes, this is an impediment to the practice of law, regardless of whether somebody is punished under East or West German law. There have been a number of cases regarding the criminal responsibility of former East German judges, but those cases were brought only after reunification, after 1990. In those cases, the judges were sentenced in accordance with both East and West German law, insofar as West German procedural law applied, but the material standards of East German law, as it was applicable at the time, were applied to those cases. In those cases, perversion of justice was also a crime under East German law, even though, in practice, it was the state which required judges to act in a certain way, and in particular when it comes to politically motivated cases. The perversion of justice, the conviction for perversion of justice actually served as a threshold. There was, in many cases, for the local bar associations, the limit which they drew, the line they drew, basically saying, if a court found you guilty, even under the more lenient laws, of a crime of perversion of justice which carried a conviction of at least 1 year in prison, which is not nothing, then your previous behavior as a judge in East Germany was so serious as to warn this person not to be admitted to the bar in reunified Germany. Now, think about what that means for those who are concerned. They've trained as lawyers, they worked in one legal system. This legal system changed, they had no influence on whether it would change or not. And all of a sudden they find themselves without a job. So, in this case, the conviction is not just 1 year in prison. The conviction is that you lose your livelihood, that with a change of the political system, you're also no longer allowed to work in your profession. Germany has been very harsh in the way we've been dealing with that. As far as I'm aware, almost no other country has dealt with judges from the socialist system in the same way. And I think part of the reason for this very harsh approach is the particular German experience, also in the wake of World War II. Because then there was certainly the mistake made that a lot of judges from the Nazi regime still played a role in West Germany after World War II. Now, in 1990, Germany was in a much better situation insofar as there were lawyers, there were attorneys. There were qualified people from West Germany who were willing to move to the East, practically on a moment's notice, and to take up jobs there, as judges, as prosecutors, as law professors. But it was only this benefit which Germany had through the people who had been educated in the West German system that allowed such a strict approach with regard to judges from East Germany. The question then is, does this teach us anything for the future, or is this a one-time event? Is this something which is not repeatable? Is this something which is not even transferable to another country? Because after all, other countries might face a similar situation, not just now in Eastern Europe in the 1990s, but in general. There will always be situations in which legal systems change dramatically within a short time. Think of the Arab Spring, for example. What do you do with the judges there? What do you do with prosecutors who worked under an undemocratic regime? And I think the lesson here is simply that good morals do matter. In particular among attorneys. And one question that already came up a little bit is, whom do we actually serve as attorneys? And because the whole question, who is allowed to be an attorney, touches at the heart of the matter. It touches at the question, who are we as attorneys? Do we just serve our client? Do we serve our own wallets? Under German law, there's this idea that the attorney serves the justice system as a whole. But maybe we also have a third master, our law firm. What responsibility do we have towards our employees, for example? This ideal of serving justice in general has to lead to higher standards, but how these standards look like, how we define them, that's something which attorneys will have to answer each and every day again. We've seen the Russian example that there are very specific laws regarding the ethics of lawyers. In Germany, there are a few basic laws, but the ethical standards are included in documents which have been adopted by the bar associations, similar to the situation in the US. And I think we are talking about an evolution here, a continuing process. And it's this nature of legal ethics which makes it difficult to write it into stone, to lay down very clearly what is demanded of lawyers. And maybe as an afterthought, because after all we're in Kaunas and I see quite a number of students here. Here in Kaunas you have the benefit of two really good role models on how ethical behavior can look like. There've been two men who have been living in Kaunas several decades ago who went against all the rules of their profession and in doing so acted in a very ethical way. I'm talking about Shiona Sugihara and Jan Swartendijk, who many of you might be familiar with. In fact, Mr. Swartendijk got a posthumous order from the Republic of Lithuania last year for his actions. There were consular officials who worked here in Kaunas during World War II and who issued visa for Jewish refugees. Mr. Sugihara from the Japanese consulate issued transit visa. Mr. Swartendijk issued visa for the Dutch island of Curaçao. In doing so, they saved thousands of lives, but they completely went against their orders. They completely went against all the regulations in their national legal systems. I'm not telling you to go against all rules all the time, but especially when we're talking about ethical rules, when we're talking about the ethics we have to choose, the loyalties we have to choose between the law on one hand and our own ethics or professional ethics on the other hand, or even between professional and personal ethics, between our responsibility towards our employees and our clients, for example, then yes, sometimes it might be worth breaking the rules. Thank you for your attention.